I must, in the fairness of things, start with Justice Banerjee. You are somebody who's had to be on the bench that today we're talking about. You've had to try cases, you've had to look at law, you've had to, in a way, put emotion to one side and look at a case. Now, when we look at the Umar Khalid case and not getting into the allegations, whether they're true, false, just looking at the fact that he has not had a trial for 5 years. And today the Supreme Court said that they could apply for bail after another year, once a certain phase in terms of documenting the witnesses was over, and that the delay in trial by itself did not qualify them for bail today. Did you agree, Justice Banerjee, with the response of the Supreme Court?
Two things. The Supreme Court has interpreted certain facts and has come to a conclusion based on those facts. Now, my interpretation could be different, but once it's interpreted those facts to find that a strong prima facie case had been made out by the prosecution, it's justified. Because we do not get prompt trial in this country, it does not mean that every person whose trial is delayed must, as a matter of rule, be enlarged on bail. Thirdly, and most importantly, and despite the caveat that I may have seen things quite differently, just to justify what has happened, because let us not belittle the highest court of our country. Let us not, denigrate the institution to that extent. What the Supreme Court says is that till the witnesses are examined or that the investigation to that extent is complete, they should not be let out. Now, one of the considerations in granting bail is to what extent would the accused be able to influence the evidence that has to be gathered or the process of investigation. So it has given reasons which are in tune with the principles to be followed. But as to the interpretation, of course, you and I may think differently from how the Supreme Court has.
Can I, before I open it up, just push you a little bit to make sure I've understood you correctly? I think what I'm hearing you say is that the Supreme Court has taken a bunch of information before it and interpreted that information to make the case that there's a prima facie case made out against Umar Khalid and Sharjeel Imam that is somewhat different in gravity from the five co-accused who've been granted conditional bail. I think what I'm hearing you say is you personally probably would have looked at that information differently. But once the Supreme Court has looked at it in this way, they have a legal basis to do what they've done. Am I correct?
Absolutely.
But you would have looked at the information differently?
Probably, possibly. Two persons may not agree. And considering the other circumstances, their status, their ages, I would definitely have looked at it differently. But, if you rely on a principle, then it's fine.
Sanjoy Ghosh, let's bring you in, because I know from your comments on X, unlike Percy, who hasn't expressed an opinion yet publicly on this case, that you were shocked. And that I think you expected a bail to be granted, maybe with a list of conditions, but that conditional bail was for the other five accused. Now, Justice Banerjee, I think, pretty much indicates that he would have looked at the available information differently, but any judge has the right to look at the information placed before him or her in a certain way, and the judges haven't gone against the principles of law in their response. I'm assuming that you think they've gone against the spirit of the law.
Barkha, thank you for having me. Well, most interestingly, this judgment has enlarged some people on bail. So it's not that people have not got relief today. So what is interesting is to see how has the Supreme Court differentiated those who were denied, namely two people, Umar Khalid and Sharjeel, and those who have got the bail. The Supreme Court now lays a very important principle. The Supreme Court says we are not going to go by a general bunch of facts. We are not going to go by the general conspiracy. We are going to see the individual roles of each of them. Now, I'll just take a minute. The Supreme Court has listed out in para 158 what was the individual role of these two, Umar Khalid and Sharjeel Imam. And they are, one, creation and administration of mobilization platforms, basically WhatsApp groups, dissemination of written material intended to galvanize participation, meetings and coordination, and public exhortations for articulating a strategy of disruption. So this is what is being held against them. Now, the Supreme Court seems to indicate that these people, or accept the prosecution case, that if a person, in the course of trying to create a pressure tactic on the government, trying to create an agitation, if you set up a WhatsApp group and you make exhortations. Now remember, none of these exhortations are exhortation to violence. Neither Umar Khalid or Sharjeel Imam has said desh ke gaddaro ko goli maro salo ko. There is no such exhortation made of violence or doing any kind of harm to any person. What is at one stage, the Supreme Court quotes the statement made by Sharjeel Imam. He says that I'm going to, we can chakka jam and we can chop off northeast out of India. Now let us take it that Umar Khalid and Sharjeel Imam are the most disgusting people on earth. We don't have to like them. This is not a case of a liking contest. Okay. Now let us assume that Umar Khalid, Sharjeel Imam said, we can do a chakka jam and we can cut off northeast or Assam. Let us assume Umar Khalid or Sharjeel Imam pleads guilty to this offense, that yes, we said this. Now, we all know nothing has happened. We all know no northeast was cut off. Now, what is the sentence any reasonable judge would have given a person who has admitted and confessed to this offense that yes, I said this? It's a very bad thing. Would you sentence him for more than 5 years imprisonment? So that is the point over here. What is now, having said all of this, you are letting out and enlarging some people on bail. And for these people, you are saying apply after a year. Why after a year? Either you stick to your principle that this is a special law which you spend 40 minutes.
So Sanjoy, you're saying even if the speeches or some speech attributed to Sharjeel Imam is considered inflammatory, it didn't result in violence and therefore it cannot be seen as inciting violence?
I'm not saying so. I'm saying even if it is a speech inciting violence, if there is no chain to show that the Delhi riots are directly related to this, for that inflammatory speech, I think even if he's convicted, 5 years imprisonment is more than justified and sufficient for that person who has made such a speech.
And you're saying here they are 5 years without a trial.
Without a trial, without charge sheet being framed. And the Chief Justice is here. Ask him that when charge sheet is not framed, when there are more than 10, 20 so-called protected prosecution witnesses, you think it is practical that a trial will, or this witnesses recording will be over, charges will be framed, and everything will be done within a year?
Brief response there, Justice Banerjee, before I come to Percy and Susie Ben. The fact is that Sanjoy is making 2 points. One, that they've already spent as much time in jail as they would have probably done had they been convicted. And two, is this really a finite time of a year?
Probably not. Probably not. If it couldn't be done in 5 years, how can it be done in the next year? How can you be certain? Why should they have to wait another year before they apply? Why not 2 months down the line? And why exactly after a year? These are, things which probably are somewhat left to interpretation. But the fact remains that certain grounds have been given. Those grounds are pegged to legal principles. Now you can always, distinguish the grounds. You can always take a different view, but the grounds are at least pegged to the principles relevant for considering or granting bail.
Are you comfortable with how the judiciary has handled this case?
No, not at all. If we must allow dissent, we must have a year out for what the other side says, and drumming up support for opposing something that you do not believe in per se is something which is not actionable or should not be actionable in a civilized society, in a responsible democracy.